This is case number 22179603. This is Asset Direct Debt Credit Acceptance Corporation versus Tina Fala. The matter is before the court, set on for a general hearing. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
Thank you, Mr. Werber. Good morning to you, sir. I am looking for Tina Fala. If you're on this Zoom, please say something at this time. A person who indicates that they live in the city of Detroit on Mark Twain Street. If you're on the Zoom anywhere, please say something at this time. I did receive a letter from the defendant in this matter, and it was directed to credit acceptance regarding an outstanding debt. Recently notified me I have reason to believe that the debt amount owed was less than the debt listed. I was under the impression that after the vehicle was repossessed, I suppose that means the vehicle would be sold, and I was responsible for the remainder of the balance. This vehicle was not for my, this vehicle was for my ex-husband. He left me with the responsibility of paying his note. I'm writing this letter to see if there can be a mutual amount that can be paid to settle the debt. All right. It looks like the defendant has not appeared. The letter seems to be one that was reaching out for trying to reach some resolution that would result in an amount less than planned for in this case. Anything you wish to bring to the court's attention at this time? Have you spoken with the other side, counsel?
No, Your Honor. We did receive the letter. I wasn't sure if the court received it and accepted it as an answer. So we went ahead and filed a default that was entered by the court. And I believe you should have a default judgment in your file. If you do, I request that the court enter the default judgment for failure to appear at the hearing today.
All right. I don't have either of those items populated in the file. We'll search it out for sure. I'm going to get a register of action just to see what has occurred so far. Again, it's 22179603. All right. So I will enter judgment by default to appear. Those things have not.
You don't have it.
Yeah, I do see the entry of default on 5/17/22. But I don't see, well, I see the entry of default on 5/20/22. But I don't see a judgment contained within the file. So, counsel, if you could follow up by emailing a copy of the judgment to me, that would be helpful, and I'll get that all signed up. The email address that you want to send that to is Latifah, LATIFAH last name is Hunter, HUNTER at 3636th districtcourt.org.
So Latifah.Hunter@36districtcourt.org.
That's correct, sir.
Okay, we will prepare a default judgment and submit it. Thank you for your time this morning, Your Honor.
All right. Thank you, counsel. Good day to you, sir.
You too.
All right, the court now calls case number 22178326. This is Al Rada Bakery LLC versus Eastbourne Partners LLC and Trinity Construction LLC. The matter is before the court. It looks like I received the verified answer. What was in March, and it's set for a hearing on a motion for summary disposition. Your appearance for the plaintiff in this matter, please.
Your Honor, Mohammed Zahir, P number 5/2020, appearing for the plaintiff.
Good morning, Mr. Zahir.
Good morning, Judge.
And for the defendant regarding this matter, your appearance, please.
Good morning, Your Honor. Jan Rubenstein, P 57937 on behalf of Trinity Construction.
All right, and good morning to you as well, sir.
Good morning.
Is there someone here representing Eastbourne Partners or any information about that from either of you?
Judge, I do not know whether they were served or not. I mean, I have no idea. I took this case from attorney Ali Dagger. I substitute for him, I think in March. He's the one who filed this complaint. And when I took the case, there's already outstanding motion for summary judgment, which is I replied to it. So I do not know. I have no record whether the plaintiff, the defendant actually served or not. But just to let you know, the Eastbourne right now, they file a lawsuit in the Wayne County Circuit Court in front of Judge Sullivan. And Judge Sullivan, and 2 weeks ago, he ordered facilitation to resolve everything. So now, and we selected Judge Robert Young, the former Michigan Supreme Court, and he is going to be the mediator for the entire case. And this case apparently is part of the same lease. So I'm going to leave to brother counsel to argue his motion, but I think that this case should stay. I just filed a very fast motion yesterday asking your honor to stay everything till the mediation is over. You know, hopefully we can resolve everything because this case is out of the same lease. They filed a lawsuit in the circuit court against my client. Now my client is a plaintiff here, is defended in front of Judge Sullivan. So that's what I'm thinking, that we should stay this till we resolve, maybe we can resolve everything at once.
Your Honor, well, to answer the court's question, which was, where's the other attorney? They were served, but this motion doesn't really impact them necessarily. I mean, Eastbourne and Trinity, I'm sorry, Eastbourne and Alrata have their dispute or disputes and they can proceed as needed. My motion.
Just one moment, Mr. Rubenstein. Mr. Cox, you have some involvement on this matter, sir?
That's correct, Your Honor. Good morning. Aaron Cox, P69346, appearing on behalf of Eastbourne Partners. Judge, I do represent Eastbourne, but I do agree with Mr. Rubenstein's statement that the motion doesn't really concern my client.
Gotcha. All right.
Judge, I do apologize for my tardiness. I didn't get a renotice on this thing, and I thought it was at 10, not at 9:45.
All right. And my understanding is that that you have a matter in circuit court that touches upon these same issues. Is that correct, Mr. Cox?
My client filed an affirmative action against Alrata Bakery and its guarantor in circuit court. It asserts different claims, but certainly they arise out of the landlord-tenant relationship between the parties.
All right, Mr. Rubenstein.
Yeah, I was just, my client's not a part of that case, nor is my client a part of the facilitation that they're purportedly going to. These are not contract claims against Trinity Construction, contrary to what Mr. Zahir represented. These are claims for 2 items, conversion and civil conspiracy. The background here, Your Honor, is actually fairly simple. There was apparently some do-it-yourself work done at the property. This involves Mr. Cox and Mr. Zahir's clients. There was roof damage caused when there was some hoods installed at the property. My client, pursuant to the lease, had the obligation and the right to make the repairs, the emergency repairs to the roof, and withhold funds from the tenant. None of that has anything to do with my client, Trinity Construction, Your Honor. Trinity Construction was hired as a construction manager to repair the damage, which they did. So there really is no connection to my client for either of these cases. We applaud the other 2 parties in this case to go duke it out and to have whatever battle they want. But my client never withheld any money from the plaintiff. Okay, my client was paid for services rendered by Eastbourne. Very simple. They're separate companies. There's no overlap. In the response, it does indicate that they feel that there's an overlap because they have similar registered offices and things like that. But there's different services that were rendered. There's no dispute that my client Trinity rendered service, that roofers were retained, repairs were made, and my client earned the money that was paid, but it was paid, mind you, from Eastbourne Market. There, you can't even track funds collected from Alrata to directly going to my client. That's impossible. But my client was paid for services rendered. They shouldn't be a part of this case, Your Honor. The motion for stay was filed yesterday morning. It looks like it was walked into the court. I got an email with the motion for stay yesterday. Of course, I had no opportunity to respond to it. I think it's a little bit of gamesmanship to drop this on us at the last minute. My motion was filed March 24th. It's been sitting out there for 3 months now. Obviously, if they wanted to file a motion for stay, I would dispute it because my client's not a part of any other proceedings with these parties. But I would at least have the opportunity to dispute it. Council's had 3 months to file that, and he filed it at 8:36 in the morning yesterday and sent me an email some hours later with a copy of a motion that was not noticed up for today. So I disagree with council that there should be any type of stay provided, at least as it relates to my client. This looks like a way to avoid summary disposition, and this, in my mind, is an otherwise simple matter. My client has done nothing. There's no contracts. There's no privity of any relationship between Trinity Construction and Alrata, and my client didn't receive any assets of Alrata. They weren't paid by Alrata.
Thank you, Council.
Yes, can I respond?
This is our, I'm gonna let you respond, but I understand the proposition that you raised, that the matter being arbitrated by or facilitated by former Justice Young or any person would tend to result in some type of global resolution of this, which sounds to me like it would likely result, if resolved, it would likely result in a dismissal of Trinity out of this matter. Of course, Mr. Rubenstein is saying that Trinity shouldn't be here anyway. So go ahead, Mr. Cesare.
Well, Your Honor, one of the things, whatever he argue, if you think of it, is a question of fact. Number one, he filed this motion in lieu of his answer. Discovery hasn't started. We don't know what's going on. Apparently, his client performed fixing the roof for $2,000. They charged my client. They took money from him for $6,000, and I think that's why he's suing them, because the amount of repair compared to the amount they charge or they withdraw was too high. I understand. And one of the exhibit that Mr. Robinson attached to his motion was the same lease. So he's arguing, and one of the exhibit for the court to consider was the same lease that between my client and Eastern Partners. So I do not know. I think we should have some discovery here. And if his client is not liable, I am more than happy to dismiss him. And in fact, I sent an email to Mr. Rubenstein, ask him if we can resolve this. His response, I'm not resolving unless you dismiss me with a prejudice. So he put condition on me, which has become impossible for me to negotiate. So I would like to know what's going on here. Like I said, I took this case. I would like to have some discovery here. I would like to know what's going on here. And I think that this client and Eastern, they work together. I mean, the Eastern, they are big management company. And I think the construction company is one of their contractor, or according to my client, which is, I don't know, he said they are relative. So I think we need some discovery here. By dismissing the case at the early stage, I think this is very unfair and unjust.
Your Honor, brief reply, if I may.
Just one moment, sir.
Sure.
Okay, so I see in your complaint, Mrs. Zara, that you involved Trinity in your allegations through counts 3 and 4. That is the statutory conversion and civil conspiracy. There don't seem to be some pretty high bars in a case where you are claiming breach of contract and fraud as it relates to the defendant Eastbourne. What are you basing? How do you survive the motion for summary disposition with? You certainly have allegations set out here. It doesn't seem to me that there was anything with any significant degree of specificity. So tell me, what are you hanging your hat on here?
Judge, I have to be honest with you. I'm not the one who dropped this complaint. I substitute for attorney Ali Dagger. So if you see the signature on the bottom of this complaint, I didn't sign it. I did not draft it, but I read it. And I have to be honest with you. I don't like it personally. I don't think it's a good complaint. So maybe I can ask Your Honor if I can amend it, but rather amending and go into litigation, see if we can resolve it. I am more than inclined to resolve this.
Yeah.
I'm more than inclined to resolve this, yes. The complaint that was drafted, I don't think it was a great complaint, but usually in a situation like this, usually we ask the court if they can allow us to amend the complaint, but rather than, amending the complaint and go into litigation, and a case like $6,000 case is not worth it. And that's what I'm more inclined to resolve it, ASAP. So that's what my thinking. If we go into facilitation, let's resolve it, resolve everything, get over with. My client is a businessman. He opened a restaurant not to litigate or go into court. He opened a restaurant so he can make a living for his what's called it, for his family. And now he's in double litigation. And by the way, Judge, now 11 o'clock, I have another case, eviction in the same court. Last week, we have court in front of Judge Sullivan. This is gonna create heavy impact on my client, how much of profit he's going to make. And those lawyers, they file lawsuit, they file motion, they file this, hoping they can make, with due respect to them, money out of my client, because the lease said, well, if you do this, we're gonna add attorney fees. And, I try to avoid those. And that's what's happening here.
Your Honor, may I briefly?
Just one moment, Mr. Rubenstein.
Sure.
To the best of your knowledge, and I'm not suggesting that this would happen, but to the extent the court allow an amendment freely as justice so requires, can you think of anything that you would add by way of amending your complaint that might survive the motion for summary disposition? I understand that it would make sense, obviously, if it always makes sense if there's some resolution that's afoot that may make all the parties sufficiently happy and willing to walk away. But on the issue of amending the complaint, I mean, what is it that you would proffer to the court by way of the allegations in counts 3 and 4 that would change such that the court would even consider an amendment at this time? Sarah, did you hear my question, sir?
Oh, that's for me, Judge?
Oh, yeah, that was for you. I'm sorry, sir.
Oh, I thought.
I'm thinking about the whole issue of, and I know that you have requested that, and I don't know that even if there was a request that the court would be inclined to grant the opportunity to amend this matter 3 months after a motion for summary disposition was filed. But if you were going to amend it, I guess I'm asking for your imagination and creativity as it relates to counts 3 and 4. What might you be willing to do to present this to the court in such a way that it would survive a motion for summary disposition? Any idea?
Well, Judge, I mean, the civil conspiracy between two companies, I don't see this one will stand. I have to be honest with you. And I don't think the conversion is going to be a good count. I mean, I'm not going to start to sugarcoat it here, but could be another issue that I am going to look to it, such as a contract or some kind, who took the money from my client? Somebody took money from my client, because I believe that the construction company spoke with my client and they told him this should not cost more than 2,000. Now they withdraw 6,000. So really, I mean, my client told me that they told him 2,000, they took 6,000. I think this is all about this lawsuit. So, but I disagree. I agree with you that the civil conspiracy between two companies, I don't think it's going to be a good count. Usually you don't do conspiracy between companies, usually conspiracy between individual and behalf of the company. So there, the way that this complaint written was a little, poorly written, could be corrected in a fashion, because company cannot talk, individual talk. So.
Thank you, Counsel. Last word, Mr. Lewis.
Thank you. Just a couple things. First of all, counsel makes representations as they have an eviction, they have a facilitation. They don't. My client is involved in none of that. If there's a facilitation upcoming, it doesn't involve my client. I haven't been notified of it. My client's rights and interests are not protected as it relates to that facilitation. There's also, and I'll submit an offer of proof, and I believe every attorney on this case would stipulate that nobody's arguing that Trinity took this money from plaintiff. The money was taken by the landlord. The landlord paid my client. That's in the pleading. Everybody agrees on that. I believe even Mr. Zahir, as an officer of the court, would have to agree with that. So, Your Honor, at this point in time, I mean, counsel made a representation. This is a $6,000 case. My client's incurred attorney fees since the beginning of this case. As the court knows or should know, I'm not a free lawyer. There's never been a request to amend the pleading prior to today. Nobody's called me up and asked me for that. In the event that the court is inclined to allow any latitude in that way, then I think security for costs would be necessary. I mean, there's really no dispute here as far as what happened. The facts are not in dispute. Eastbourne withdrew money from the tenant. Eastbourne paid my client for services rendered. We all agree on those facts. So if we all agree on those facts, I mean, even as counsel indicated, these counts 3 and 4 really shouldn't survive here. So apparently wants to throw a Hail Mary at finding some other count. Meanwhile, my client's paid me a lot of money thus far on a small case, and this shouldn't continue beyond today. I applaud the parties to go try to settle all their issues. But again, I represent Trinity Construction. We're not involved in any of that. We're not involved in any Wayne County Circuit case, any evictions. We've been sued in this case, and we've been sued wrongfully.
Judge, if I may, I mean, Eastbourne partner hired his client to perform a repair in our building and you know, in my client's business. So, and secondly, the information that I have, that this landlord and this roofing company are both either related or they work together. And that's why discovery in this situation, it's a very important.
All right. I've listened to the arguments of the motion for summary disposition offered. That is the motion offered in lieu of filing an answer in this matter. And I understand why no answer was filed, and there was a preference for the filing of the motion for summary disposition. I'm strained to find a reasonable cause of action even if I view the complaint in the most favorable light towards the plaintiff in this matter. I don't see how Trinity Construction is connected to this. I don't believe that there is a genuine issue of material fact. It just does not seem that there is, based upon my reading of the motion, my hearing of the arguments, that Trinity is connected to this matter such that they should be brought into this action. For that reason, I'll grant the motion for summary disposition, and accordingly, the complaint will be dismissed as it relates to Trinity Construction LLC. And with regard to the balance of the case, I know that the parties are litigating this elsewhere and have a facilitation set up. And so what I'm going to do is I will adjourn the matter over to give time for that process to complete. Do you have a facilitation date set as of yet?
No, we don't, Judge.
All right, so what I'll do is I'm going to set it out. I'm going to set it out 60 days hence as a review date. I'm going to give you a specific date in just a moment. That'll just be a review date. You can update me and tell me where things are at that time. And if it's resolved, it's resolved. If not, the court will at least be able to put a calendar on it to see what happens next. September the 1st is going to be the return date on this, September the 1st, and that's going to be at 10 o'clock a.m. September 1st, 10 o'clock a.m. Mr. Rubenstein, if you'll submit an order granting the motion for summary disposition and dismissing as to the defendant Trinity, the court will assign the order accordingly.
I will, Your Honor. Do you want me to put the adjournment of the balance of the case in that same order?
That would be great. Don't be getting a notice from the court, but I always like to put that in the order. So thank you.
That would be fine. Thank you, Your Honor. Thank you, gentlemen.
Thank you.
Good day to all.
Thank you, Your Honor.